Okay, State versus Franklin Tucker, 2017 CF 841. Everyone's here, so are we ready to proceed with defense evidence?
No, Your Honor. I filed a motion for continuance based on disqualification that I'm filing.
Could you elaborate, please?
Well, I filed a motion for continuance because the was it 2.330 of the Judicial Administration? It gives you 20 days to file the motion for disqualification, and in order for it to be procedurally sufficient, it's going to take a little bit of time because it requires service, etc. So I took and I asked, again, I put in a motion for continuance for 10 days, which is half the time, to get it ready.
State?
Judge, we would object to that. We are here. We have a jury waiting for us. The state is prepared to go forward. At this time, that would be, to us, a fabricated delay, and we would object to it.
Yeah, the motion is denied.
No, Your Honor, if I may be,
Sir, I heard what you had to say. Is there some rebuttal argument?
Yes, there is a rebuttal. It actually does say during trial that yes, this still is applicable, and that yes, because I am afraid of not getting a fair trial, it seems like denying the motion and not allowing me the time to file the motion to disqualify would just be a way of circumventing the motion to disqualify.
Denied. So, you ready to present evidence this morning?
No, Your Honor, because again,
Okay.
and don't get me wrong, I did go ahead and, I got the Chief Justice involved with this, just to make sure that we can get this, cleared up without as little as more, what's the word I'm looking for? I don't know, but the thing is, Your Honor, the idea that I'm going to get a fair trial at this point when I'm not being allowed to present a defense, you already told me that you're not going to allow me to call Todd O'Quinn because you won't issue an order for me to get him here. Yeah, I mean, there's no chance of me getting a fair trial.
I'm not going to go and rehash what happened yesterday. There was never a motion submitted nor pending for such relief. So in any event...
Your Honor, you said you wouldn't give it to me.
In any event, sir, so you do not have any of the supposed witnesses that you were instructed to have that you said you were going to have today, is that?
Your Honor,
Sir, I'm just asking you a straight...
I'm giving you an answer here, sir. After what you told me yesterday, I called those witnesses and told them no. You don't have to come to court today because, again, Your Honor made it very clear that you weren't interested in my witnesses.
Okay. State, you have some response to Mr. Tucker's defiance of the court's instructions, his lack of preparation, and...
I think the court's been more than indulgent for his requests. The court never denied him anything yesterday. He's got no witnesses to present. The state would request that we keep moving forward.
Okay.
If he's going to rest this morning, Judge, the state does have a rebuttal case that we're prepared to present. Want to go ahead and...
Well, when you say if he's willing to rest, I didn't hear anything to that effect.
Okay, well, at any rate, Judge, depending on where we go today, if we're able to get to it, the state does have a rebuttal case to present, narrowly tailored to the evidence that was presented by the defendant yesterday through Paula Belmont's testimony. And as far as the defense witnesses, I have no, the Your Honor's put them on notice that they should have been here today. And if they're not, we would request that the court continue moving forward with this trial.
Okay. So, any response to that, Mr. Tucker? Because
Your Honor, again, you made it very clear yesterday that you even went as far as to say you didn't care what I had to say. So, I mean, the idea that I was going to have those witnesses here and ready to go in lieu of yesterday. I mean, if you would like to give me a day to get them here, sure, I can get witnesses here. But the thing is you made it very clear to me yesterday that you weren't interested in that. And if you are interested in letting me present the defense, I'm more than happy to.
in any event, I'm looking for any input from the state because he was told to have the witnesses here. He doesn't have them here.
Judge, I can even tell the court, the witnesses that he wanted to bring in today, I don't believe are even under subpoena.
Mr. Walker and Lieutenant Scabilia, their subpoenas were expired, but they were willing to come in today to testify. The defendant, it's our understanding the defendant called them off, told them not to.
Okay, so he
That's
okay, so you don't want to present them?
No, I do, Your Honor, but
Well,
I need to be able to do it, Your Honor. I mean,
Sir, you've had opportunity, so
I mean,
you're
if I may make a judicial notice, then again, I am objecting to moving forward, and I'm being forced to.
Yes, sir. You announced ready for trial. You've been given ample opportunity to present your witnesses.
I don't think so.
And you have apparently decided you didn't want to.
I was told, Your Honor. Again, I was
sir,
told
I know
not to.
you're going to repeat the same things, and that's fine. But
Okay.
at this particular point in time,
If you're going to force me to go to close, I mean, again, it's a mistrial.
excuse me, sir.
It would be a mistrial, Your Honor.
Sir,
You're not allowing me to provide a defense. You are
Sir,
telling me
you can state and twist and spin whatever you'd like to. The fact of the matter is there's a clear, unequivocal court order that you have your witnesses ready to go, that you refuse to abide by it. So that's
I'm
the
sorry, Your
bottom
Honor,
line. And
maybe
I'm
I
not going to
misunderstood.
really argue with you
No,
anymore,
I mean,
sir,
Your Honor,
because
was it a written order, Your Honor? Because I haven't seen
it was verbal, just like
Maybe I misunderstood then.
No, sir, you didn't misunderstand anything. You said, in fact, oh, I'll have the motion to disqualify. Okay,
Yep.
you don't have the motion to disqualify. I said, have your witnesses here. So in any event,
It would have been
I'm not going
procedurally
to argue with
insufficient.
Mr. Tucker, so.
Okay. Your Honor, again, I'm going to have to file an appeal on this decision now.
Sir, file whatever relief you want to see.
I
That's
do.
all part of the process. But in the meantime,
This is a railroad.
we're going to go forward with the trial in one fashion or another, so I'm just looking for some input from the
Sure,
state.
Judge. So, just so the record is clear, Your Honor had directed the defendant to have his witnesses here yesterday. We got through Ms. Belmonte, the other witnesses weren't here. Your Honor gave the defendant, he said he'd have them here today. They're not here today. The state would request that we go forward. If the defendant isn't going to present anything else, then the defense needs to rest, and the state plans a rebuttal case.
Okay, so I'm going to take a moment to reflect on these developments. I believe I told the jurors to be here at 9:15, so I will reflect upon it and be back in a few. So we're back. State versus Tucker, 2017, CFA 41. Court having deliberated upon the latest development in this case, finding that contrary to the court's instruction, that the defense does not have any evidence or witnesses to present this morning, despite the fact that knew that the jurors were coming in, knew that the case was underway, despite the fact of not having any witnesses available yesterday afternoon. So, in view of all the developments, the court finds that the defendant's case is complete. And we're going to go to any rebuttal.
Yes, sir.
Then we will excuse the jurors. We will have a charge conference, and tomorrow we will have closings. So,
Very well, Judge. Your Honor, would you like me to proffer to the court what my rebuttal case will be?
yes.
Okay, so we've got Officer Danielle Malone here, former Officer Danielle Malone, and we intend on playing some excerpts from her interview with Paula Belmont at the hospital the night of the crime. They're on body-worn camera, so I've got the thumb drive here with the excerpts that we intend to play. These excerpts will completely rebut the testimony that the defendant introduced yesterday through Paula Belmont's video deposition testimony. In that video deposition testimony, she talked about how she could tell it wasn't Tyrone Tucker, the second person, et cetera, et cetera. Well, on this video, which was the night of the crime, she completely rebuts that and refutes that with her statements to Danielle Malone. In addition, Judge, Paula Belmont gave a deposition back in May of 2019, and the state also intends to elicit portions or to enter into evidence portions of that deposition, again, that directly contradict or rebut the testimony that she gave yesterday. I've prepared a list of the statements that the state intends on using for the court to review if the court would like. I've also got copies for the defense here too.
Your Honor, I would probably be objecting to hearsay, but, you know, or at least like to know the exception that we're going to use here.
Judge, it's a prior inconsistent statement of the witness, and it's coming in to prove, that she made an inconsistent statement, which is different from the statement she made yesterday in the testimony that the defendant put on. The defendant put the testimony on. It's evidence that he introduced into this trial, and it's the state's right to rebut that evidence with a prior statement made by that witness that is inconsistent, just like with Travis Johnson. Travis Johnson was on the stand, and he was impeached with his prior inconsistent testimony. The defendant put the witness on yesterday. It's evidence that he introduced. The state's rebuttal will be tailored to inconsistent comments or statements made by that witness that rebut what she was trying to testify to yesterday.
As long as it's an inconsistent statement and not something else, then it's an exception to the rule.
Okay.
Yes, sir.
And, Your Honor, since I haven't had a chance to look at what the state's offering, if I remember correctly, did you just say that we are going to be adjourning for the day somewhere in here? I just want to make sure I heard clear, because then I'd have time to take a look at what they're offering.
Judge, when I'm handing the court, when I give the defendant, are the excerpts from the deposition that I intend on eliciting. My plan, Judge, is to simply move them in and then publish them to the jury through reading them, because those are inconsistent statements that would rebut her statements.
Well, and I'd also have to object because you already had your chance to cross Ms. Belmont.
No, the state gets to present a rebuttal case that's part of the procedure to rebut any evidence that was presented during the defense case, so long as it's genuine rebuttal and not otherwise, like opening up a new avenue. So what I said was that I was going to allow the state to present their rebuttal, that thereafter I was going to excuse the jurors for the day, that we were going to have a charge conference and have closings tomorrow. So I wouldn't expect that we'd be in session all day by any means.
Thank you.
But this is going to proceed, but if you need a few minutes to review what the state's proposing, and I'm not quite sure, Mr. Mansfield, what your proposed procedure is. I'm not clear. I mean, you gave me this page of excerpts from Paul's first deposition, May 1st, 2019. I'm not
Judge,
sure.
let me clarify. There's two different pieces of rebuttal evidence I'm going to be moving in today. The first piece of rebuttal evidence, I have the officer here. The officer is going to come in, take the stand, tell us that she went to the hospital to interview the witness, Paula Belmont, that her body worn was on, and that Paula Belmont made statements to her about what had happened the night of the crime.
Okay.
And I have that video to play. That's the first piece of rebuttal. The second piece of rebuttal are excerpts from her deposition that I provided to the court and to the defense. These excerpts are directly on point with various comments that she made yesterday, and these excerpts rebut what she said yesterday in her testimony for the defense.
Okay, so how do you want to publish that? I mean, you're
Well-
not moving this piece of paper into evidence.
Judge, I would seek to move the paper in, or if not, I would just seek to be able to publish to the jury. I say, ladies and gentlemen, I'm going to read to you the question and the answer that was provided to the witness, and I mean the question that was provided to the witness and her answer, and I'll just read it to the jury.
And, Your Honor, I would like to, again, I would object to that. I would like to, again, at least know which statements you plan on moving the jury, if you plan on moving this whole thing in here.
Okay, so the way it's done, in my experience, is reading the alleged inconsistency that the written transcript or some excerpts from it in writing are not normally the way it's done. Normally it is deposition, sworn to on such and such a date, line, page, whatever line, question, answer. The attorneys can either, one attorney can be both the questioner and the witness, or I've seen them, one be the questioner, one be the witness.
Well, Your Honor, if I may
Yes, sir.
take exception again, the state had all of this prior to Ms. Belmont taking her perpetuated testimony. They had their chance to cross her then. They had their chance to rebut that.
I believe that doesn't preclude rebuttal evidence. Now, if you need a few minutes to review this, that's fine.
Judge, and it doesn't preclude. This was evidence. This is why we didn't call Paula Belmont. This is why we let the defense call her.
I understand that. I understand that. This you can certainly present any kind of inconsistent statement if it's in fact inconsistent. So I don't know. Mr. Tucker needs 30 minutes to review some of this
Yes.
stuff, or
Yes, that
10
would be-
minutes, or 5, or
I'll tell you, I don't, looking over this, I'm going to have to take a look at the video, and I'm going to have to take a look at this deposition. Are you planning on putting the video into?
The video is going to play for the jury just like testimony.
Okay.
well, okay. So, was provided in discovery.
Yes.
Okay, so, I mean, are we having excerpts from the
Yes,
video?
sir.
Okay, so,
On behalf of the client.
for the defense, outside the presence of the jury, so just like, okay, so,
Okay.
30 minutes to go through this, and I guess we have all the jurors present? We do, Judge. Could you tell them that, we're not going to be with them till about 10:05. They can either stay there or, take a little break if they want to, but 10:05.
And Judge Jones, just for the record, I mean, our apologies. We didn't know there wasn't going to be a defense presentation today, or I would have addressed this yesterday afternoon.
I understand.
And one more thing, Your Honor. I mean, again, they did call her when we did the motion to perpetuate. That was your witness.
Understood. Understand, but it was presented in your case. That's the difference. That's like I was explaining yesterday. The deposition is one thing, but who chooses to use it is an entirely different thing. So anyway,
Thank you.
we'll be back at 10:05. jury up.
Your Honor, I would actually have to take a little bit longer to review these. I'm reviewing it.
Okay, so we're back. Anything further before we bring the jury up?
Your Honor, I would actually have to take a little bit longer to review these. I'm reviewing an entire deposition, and the videos that they brought are clips from videos, and I'm trying to get the context of where the clips came from.
Judge, typically in a rebuttal case, it has to be narrowly tailored to the issues that you're rebutting. So I took clips from the interview with Paula Belmonte at the hospital. The clips, I think, total like 1 minute and 20-some seconds. The defendant, I guess,
I'm just
wants
reviewing.
to watch the entire video. I have no objection to using the entire video, whatever way he wants to go, but that's where we're at, I think.
Your Honor, for me to know that, I just have to review it, that's all.
Review what?
I'm just reviewing I was actually reviewing the video right before you came out, Your Honor. I'm trying to make good use of my time. There's actually 3 videos, and I'm not even sure which one it is.
They're excerpts from the 3 videos where she talks about her inability to ID the second assailant. That's what they are.
Okay. And,
How much more time would you need?
I don't know, Your Honor. Again, I'm not going to need that much time. I mean, as far as reviewing the videos, but then I also have to review the depot where these are coming from, because he didn't provide the entire depot. At least not that I can see here. Again, it's being excerpts from the depot, and I don't know the context.
How much time would you like to have?
To do the entire depot and check the videos, all 3 of them, I'd say at least a half hour, Your Honor.
How long would you anticipate this presentation to be?
Judge, maybe half an hour total?
I'm just contemplating bringing the jurors out, telling them to come back at 1 o'clock, letting this unfold, because I just don't want to continue to go back and forth and have these people waiting further. So
We agree, Judge.
if that would make it more palatable or convenient. I mean, none of it's convenient for the jury, but if that would be more considerate, then we could resolve whatever objections there are to this. I could tell them to come back at 1. We'd be prepared to present to them. Then we can have our charge conference. I'm assuming, I inquired a few days ago about proposed jury instructions. I'm assuming that package is together.
It's in the process, Judge. I'm just about 90% done, but I'll have them by this afternoon, and I'll email Mr. Tucker his proposed jury instructions.
In jury verdict form?
Yes, sir.
That was my question, Your Honor, so they already addressed.
And so then, if we let these folks go to 1 o'clock, we have them come back, we have the rebuttal case, we do our charge conference. I guess that's the best way to handle it. That's way I don't have to continue to come back and ask how much more time and wait a second. Just hold on a second. Have a seat, folks. Ladies, gentlemen, good morning. Good to see you all here. So, I can assure you, I can tell time. I know that clock says 10:15, and I know I told you to be here at 9:15. So I, in good faith, believed that we'd be able to get to you at 9:15, but just like all of you and all of humanity, I can't predict the future. I do my best to try to gauge how much time things are going to take and what's going to happen. Sometimes I'm accurate and sometimes I'm not as accurate. Unfortunately, in this particular case, I haven't been as accurate as I think I normally am. So I have to, again, be very grateful for your patience, your understanding, your attendance, and all the other things that it takes to be a juror on this case. I do want to advise you that we haven't been idle here. In other words, while you're waiting, it's not like we're all taking an extended coffee break or none of the above. We're working and making progress in terms of ultimately getting the case to you. And so I can advise you that the defense presentation has been completed, that I can advise you of. And so the next step is the state's going to have an opportunity to present its case in rebuttal, which will be relatively short. And so what we need to do, or what has to happen now, in light of the fact that we've reached this juncture in the case, once again, I have to spend some time with the attorneys outside of your presence. How long is that going to take? I don't exactly know, but I do know that the best way to do it and try not to keep you in limbo is to excuse you to 1 o'clock. And that way I am as confident as I can be of anything that at 1 o'clock you'll have evidence and rebuttal presented to you, and the evidentiary portion of the trial will be over at that time. What that then means is that the lawyers, defendant, myself, will confer outside your presence. You'll be excused, and tomorrow we should be able to go to closings and deliberations. So again, I always try to be mindful of your scheduling, your time, try to give you the best feedback I can as to where we're at in this process. So again, I apologize for the wait, but this is where we're at, and I'll look forward to seeing you back at 1 o'clock, and have a good rest of the morning. Okay, so they're going to 1, so you'd think that, Mr. Tucker,
That's more than enough time.
well, no, I mean, I've got to come back here. I don't have to, but I would think I'd need to come back here at 11 to see if there's any objections. I mean, so if you have any objections, I want to be able to rule on them so we don't find ourselves sending these folks back and forth again.
So 45 minutes, Your Honor, is that what?
That's what I'm estimating.
Okay, no, I'm just checking.
So like 11:05, and
That's-
sometimes the opposing sides actually reach agreements on some of this stuff where One side may say, gee whiz, I have a problem with that, did you notice that? And the other side might say, oh, okay, we'll withdraw that one. Other times they don't, they need the judge to make a decision. So if there's any agreements and if there are any objections, if they're not, that's whatever. I'll be back at 11:05.
Thank you.
All right, so that concludes, I guess, part of the morning session. So I figured we'd come on here, and I believe I know the video that they're going to be playing. So I thought, well, why not watch it together so that we can see it? Because oftentimes the videos played in court are not of great quality. So that's what I'm queuing up right now. Give me a moment. All right, so it looks like I could only find part one, but this is part one of the hospital video that they referred to in court. So let's take a look at this and see what she has to say on here in comparison to what we've heard yesterday, and see what they're going to be playing for us. And this will be a little bit better quality, I think, than what we're going to get in the courtroom. But let's go ahead and play it.
Hi.
My friend's dead.
Huh?
My friend's dead. They said my friend's dead.
Who called you?
My friend Todd.
Your friend Todd?
He was at the house.
He was at the house?
Yeah.
Okay.
He's dead. He's dead. Can I go see him?
Not right now,
What
okay?
happened to him? I know they jumped on him and knocked him down the steps, but Todd said they stabbed him. Did they stab him too?
I don't know. I'm here to talk to you.
Okay.
Okay?
Hi, I'm Paula.
I'm Danielle, okay? I need you to tell me about the person who did this, or the persons that did this.
Okay, I don't know the one. The one that I do know, the one that was on top of me and the one that stabbed me. He goes by the name of Detroit. Big black guy.
When you say big, what do you mean by big?
Big like you, big. Big, taller than you, but big.
Okay,
Big,
stocky, muscular, fat,
stocky, big.
stocky, and taller than I am?
Yeah, he had
How
been,
much taller?
I don't know.
I mean,
I don't know, maybe about this much tall. Yeah,
okay,
Yeah,
so about
okay.
6 foot.
He had been at the house earlier, and he had been downstairs playing chess or something with Matt. I don't know, because I was upstairs. He's a friend of Anastasia Clay.
Okay.
And Anastasia had kept saying she was going to have somebody come and beat me up, steal my money. I don't know it's money. She kept saying this. She tried to have Crystal Dinklocker do it. She asked Melissa Damas to do it. Matt put a 15-day notice on her door yesterday.
Okay.
And but April's the one that brought him to the house originally. April,
Okay.
as in Anastasia, same name.
Okay.
She knows him. All I know is his nickname is Detroit.
All right, his nickname's Detroit.
He lives in
He's
some kind of warehouse.
okay.
He's in a warehouse somewhere on Front
he-
Street, I believe.
On Front Street?
Yeah.
Okay. Is he black,
He's black.
white?
Yeah, he's black.
How old is he?
In my age group, I'm 53, somewhere in that area.
In his 40s or 50s?
50, something like that.
In his 50s?
Yeah.
Okay. Any scars, marks,
I don't
tattoos?
know him that well. He's April's friend, not mine.
Okay, but you've seen him. Did you
Yeah,
any
but
scars
nothing
or
that I know of.
tattoos?
Not that I'm aware of, no.
Okay. What kind of clothes was he wearing?
Black boots. You know, like cops usually wear. He had them on tonight. He had on shorts. He had dark shorts and dark sweatshirt, dark like this. Looked like this in the dark.
Okay.
And he's had some kind of mask on, but I knew who it was. I knew it was the minute he came up there.
Okay.
Before, I don't see well in the dark, but before he even got to me, I thought he was just, I don't know, because I couldn't tell at first it was even a mask because I don't see good in the dark, but I know exactly who it was. It was him.
Okay. Who described the other person?
I didn't really get a chance to see the other person because he was on top of me. The other person was smaller and littler. Maybe. Okay, smaller and littler like her. But he had something real big in his hand.
The smaller guy?
Yeah, it didn't look like a knife, but it was big, like something long and big, and maybe like a billy club or something. I don't know, but it was about this long.
Okay, was he white, black, Hispanic, male or female?
Black, and he was all dark clothing too.
And it was a male?
Yes.
Okay, so a smaller
Yeah.
black male. About how old was he?
I don't know. But I
don't
can
know?
tell you that Detroit had been downstairs in Matt's house tonight, so his fingerprints have got to be in there.
Okay.
Got to be, because he hung out there tonight with Matt.
Okay, the other person.
The one
How
that's
old was
dead
he?
right now. I don't know. I mean, he's completely covered. I had a 200-pound man on top of me, and I was just catching glimpses.
Okay.
Roger is the one that you want to ask about that, but Roger left it. He lives in Point Santa Plaza somewhere. Roger Rugged. That's the one that...
Roger Luggett?
Rugged.
Rugged?
Yes, Rugged. Ruggitt. He's the one that got beat up by the other guy.
Okay. And he lives in the city? Roger lives in the
Lives
city?
in Point Santa Plaza, but he works at Key West Golf Course. And at this time of night, he's probably staying there. He's a maintenance. He's the lawn mowing guy.
Okay.
Okay, I'm gonna try to be gentle. I'll stop if it's too much, okay?
So I don't. If this part gets played for the jury, I don't necessarily think this is helpful to the state in the sense that she clearly doesn't describe anybody who fits the stature of Tyrone. On top of that, she directly impeaches some of the, or at least calls into question some of the testimony that Johnson presented, or at least the interview tape of Johnson, when it's clear that he's trying to put the knife in Tyrone's hand and he's putting the billy club in Detroit's hand because he knows the detective has told him, or the captain had told him, Tyrone is your key. Tyrone's the guy. And here she is flipping that around because obviously she knows Detroit's the guy that stabbed her or had a knife because Detroit stabbed her. So why the state would even want to put this on, I have no idea, because again, I don't know what excerpt they're using, but if I was Mr. Tucker right now, I'd say I want this whole tape played. I mean, this whole tape is more helpful to him, I think, than it is the state. Mr. Mansfield was amenable to playing the entire tape. I don't know if the judge would allow it, but if I was Mr. Tucker right now, I'd be saying, I want this whole hospital tape played. I mean, you open the door for it, I'm okay with it. This whole trial's a mess. Play it. Let the jury see the entirety of what this lady says. And again, in her deposition yesterday, if I'm not mistaken, in her testimony on Friday, that isn't able to be considered, she said, I didn't know who the second guy was. I didn't I wasn't able to make that determination until I started seeing things on the news and in the newspaper. And then I realized that was similar to the person I saw earlier in the evening. And again, I don't think any of this is helpful to the state, but perhaps they think it is. They think it's going to make her look uncredible. Let's keep watching.
You provided this pharmacy. Is that correct? Try to breathe, okay?
I know y'all promised me I could smoke a cigarette, and I would really like one.
There's an oral antibiotic, and there's
My hand's starting to bleed again, too. I know you bleed.
That's not up to me. I gotta get you from your post before.
How old's Roger?
In his 60s, I think he's like 65.
Very generic general information, but like I said, just something to read so if we know what to be aware of.
Are you gonna be my seamstress tonight?
No,
No?
I'm not really working tonight.
Oh.
I'm trying to help get people cleaned up.
Yeah.
You doing okay? I hear you had a bad night, huh?
Yeah, not as my friend got killed.
Yeah, I heard. I'm sorry.
He was trying to help me. He was trying to help me.
That's alright.
Do you know where Roger would have gone and why he wouldn't have stayed?
Probably because he was scared to death, like the rest of us were. There was another guy there, Roosevelt, Washington. He ran away. They were all downstairs. Yeah, I stay upstairs.
Roosevelt.
Everybody comes over and hangs out with Matt and drinks beer and plays chess and stuff.
Is Roosevelt white, black, or Hispanic?
Black.
And you said his name's Roosevelt Washington?
Uh-huh.
Where's he live at?
Somewhere on Stock Island, on Maloney. I don't know where. He's a Matt's friend.
Okay.
I don't know what I was saying. I just lost my train of thought. I forget.
Okay.
Can I see Matt?
No, ma'am.
Again? Did he get stabbed? He told me he got stabbed.
I honestly, I don't know.
Matt, I mean, my... Todd came up the stairs, he said, and he said he tried to stop the guy from stabbing Matt, and Todd got stabbed in the hand. I don't know, I'm having a hard time thinking here.
Okay. So, where were you when this all started?
Upstairs where I stay.
Upstairs?
Stay up on the top deck.
Okay, where was Matt?
Assuming downstairs.
Okay.
I can't see him on the top deck. There's 3 flights of stairs, and that wouldn't get me a door.
Okay.
So, and I kept saying that I need a door, I need a door.
Okay.
We're around.
Can I just get butterfly bandages instead of stitches? I don't want stitches.
That's up to the doctor.
Because I'm a wuss. I don't remember.
Actually, Kevin, if you want to put all the stuff in your locker.
So explain to me exactly what happened, okay?
I came running up the stairs. I could hear somebody coming up. I turned around. The guy came over and jumped on me. Started beating on me, saying, "Where's your purse? Where's your purse? Where's your purse?"
Okay. Did he get your purse?
Yeah.
Okay, describe your purse for me, okay?
Well, I think he got my black backpack, too. A little change purse. It's just like a pink, and it's got little witches on it.
Okay.
Vinyl. And my backpack is black. But I seen the other guy with that. But like I said, I couldn't really get a good glimpse of the other guy. I don't know him, but I do know the one guy was this guy they called Detroit. And
Okay.
he had been downstairs earlier hanging out with us.
What about the other guy? Had you ever seen him before?
I told you that 3 times. I don't know who it is. I didn't
I-
see his face because he had a mask on,
Okay.
and I could barely see him because I had a 200-pound gorilla on the top of me beating the shit out of me. I had no clue about this other guy, none.
Okay.
He never talked, didn't say a word. This other one kept talking. That's another reason why I knew who it was.
Okay.
And he kept saying, "I'm going to kill you, I'm going to kill you, I'm going to kill you." He told me he was going to kill me if I didn't give him my purse. The purse had $27 in it.
Anything else in there? What about in your backpack?
My wallet, I think. It's got my ID in it, and I'm supposed to fly home for Christmas. I had some jewelry in my backpack, nothing much, some change. You know, my keys, and somebody found my keys down the road. They already called me and told me they got my keys.
Where down the road? Which way down the
I
road?
don't know, I didn't ask them.
Who found your keys?
Cosmo, one of my old boyfriend, that I called and asked him to come over and help me. But the people took off in a car. I heard a car start. And go that
You heard?
way.
Does Detroit have a car?
Not that I know of. I don't know. I don't know him that well. He's not my son. He's April. Anastasia Clay can tell you everything you need to know about this guy. I don't barely know him. All I know is he was the one that did it.
Okay, so you heard a car start. What did the car sound like?
Oh my God, man, it just sounded like a car. It just sounded like a car. It wasn't overly loud or anything. I just heard a car start, that was all. It might not even been theirs. It might have been somebody coming from CVS. In my mind, it was, they went down the steps and then I heard a car.
Let's do this one first, because I want you to hold that there.
I don't know.
Okay, I'm gonna give you a break, okay? They're gonna clean you up, and I'm gonna be back, okay?
You can come back, but I'm going to tell you the same thing I told you. I don't...
Well, listen.
Ooh.
I'm gonna get that one.
Okay, I didn't know that was there.
Listen. I know you're upset,
Uh-huh.
but you want us to catch the person who
Yeah,
did
but
this to your friend,
I
right?
can't tell you anything that I don't know.
I understand that, and you've been very helpful, okay? Just while they're cleaning you up, just and see if you can just think of anything, okay?
Yeah, but I can't.
Okay.
I'd go in Matt's house and find something. Todd will tell you where this guy was sitting. Can't you go get fingerprints or something like that?
We're gonna do all of that, but
Anastasia April Clay knows this man. All I know is he had said before he lives in some kind of warehouse.
okay. And you think it's on Front Street?
I think it's Front Street. But is there any warehouses on Front Street?
Honestly, I haven't worked on Stock Island in a very long time, so I don't know. Okay.
I didn't know about that one. I grabbed a knife. I tried grabbing a knife. I probably shouldn't have. It was sharp. It was sharp knife. It wasn't big. But
Can you describe it? The knife?
it was jagged. I could feel jagged. And to me, I think it was only like about that long.
Okay.
But it was sharp. It was
Okay.
sharp. You would get.
All right. So that was video number one. I was able to find the other two videos they referenced. So we're going to watch video number two. Again, I don't necessarily believe, even though it's somewhat inconsistent, I'm not sure what they're saying is inconsistent. She was pretty consistent in what she told, except for the fact that obviously at that moment, she said at first she didn't know who that second individual was. And it was only after the fact, after she was able to see news reports, that she realized who that person was. But let's listen to the second part of this, and this one is about 4 minutes long.
Yeah. Okay. Now I know you didn't get a good look at the second person, but do you know? You said they were wearing all dark.
He was wearing something dark, ma'am. I don't know if he had shorts on or not. I know he had long sleeves on. Oh, and I think they had gloves on. They had gloves on. Well,
Okay.
the one did. Detroit had gloves on. I'm not sure about the other one.
Okay.
But when he was downstairs hanging out at that, he didn't have gloves. And them two people can tell you where he was, because like Detroit, I come up my stairs over there that night when they hang out. I don't want nothing to do with them. Sure, I don't drink beer. I don't want them people hanging around me.
I can only go up from here.
What are you doing with a hat on?
Is that bad?
Yeah, it's bad.
Why?
Because your glue's still drying.
Well, I'm protecting it.
I said, don't let nothing touch it till it's good and dry.
How long?
At least an hour.
1 hour?
Yeah.
You got it.
All right.
All right. 10:25.
There you go. They brought you to the corner in here. Right there.
Yeah, I know.
Antibiotics.
Yes, sir. No, he is another person that was at the house when this occurred.
And now we are, it went on to the third video. So this is the third video at the hospital that they have that I guess they're going to be considering. So I'm not sure what part is going to come out of this, but we're going to see.
I'm ready. I can't even smoke this anymore.
Hold on a second, Paul. I have to do something out. Move a couple things.
All right, it looks like court's back in session, so we're going to jump back over. Let's get back into the courtroom here.
Videos, he stipulated that he would play them in their entirety. I agree. You know, if we're going to play the videos, we play them in their entirety.
Judge, let me explain. The three, typically speaking, what I'm using the videos for is to rebut her statements about IDing the second person that came in yesterday. So I pulled 3 snippets from the first video at the hospital, 3 clips from the first video at the hospital. Mr. Tucker wants that video played in its entirety, so I will play the first video in its entirety where these 3 clips were pulled from. That interview goes on, they go outside the hospital. I'm not playing all that. That's not my purpose in using this video. My purpose is very specific. I'm rebutting the statements that she made yesterday on the defense case where she articulates what she knows about the second person in the treehouse that night versus what she's saying here the night that it happened.
Your Honor, if I may. Well, first off, you know, I would like to renew my objection to the videos coming in at all because, you know, again, the perpetuated testimony was supposed to be used solely if she was unavailable and nothing else after that. They had all this available to them at the time. They got their cross in, all that at the time, and now they want to go ahead and redo it. Since mine was stricken from the record, I would suggest that, you know, that yes, I'm not going to get an opportunity to redo mine. I would imagine they don't get to redo theirs.
I'm sorry, when you say
Her original
mine?
testimony when she came in to testify, Your Honor, it was stricken from the record. So I didn't get to actually cross her. I didn't get to actually direct her, I should say. But now they would like to go ahead and recross, even though they've crossed this testimony before.
Yeah, okay, well, I'm going to overrule the objection because I don't believe it's a recross. In fact, it's a rebuttal, so
Okay.
I believe they're entitled to present rebuttal, and I believe the Zoom effort with Ms. Belmont, I've covered that completely, and I don't think that's pertinent at this point.
Your Honor, I just wanted it on the record, that was all.
Yes, sir.
Okay. Now, as far as the current videos, Mr. Mansfield was not able to tell me which videos they were pulled from, so I had to go and look at all 3. I didn't do so completely, but I kind of have an idea, I guess, which videos he's pulling from. And like I said, any video he's pulling from, I'd like it played in its entirety, just for context. Because taking clips out of context, taking sound bites out, I don't like that idea. Again, it has a danger of prejudicial impact on the jury.
So, is there any...
Again, I have no problem playing the video that incorporates all 3 of these statements, but once the last one is made, I'm not moving anything in beyond that last statement about ID. So to play that other, that's not what I'm planning on presenting.
Oh, okay. Just so I'm clear. Just let me understand the issue here. The state has, when we say a video, could you again identify what, where, when?
Yes, sir. It's a video at the hospital the night of the event when Miss Belmont was taken to the hospital, and Danielle Malone approaches her in the hospital and begins to ask her questions about what happened at the treehouse, and Miss Belmont gets into detail about the assailant, both assailants actually.
Okay, so there's portions of that you believe rebut assertions, statements in yesterday's deposition to perpetuate.
Correct, Judge, that's correct.
And Mr. Tucker would like to have context, so you're amenable to that interview in the hospital being played.
The portion of the interview that addresses the ID of the second assailant.
Okay.
Then that interview goes on, but that's not rebutting anything at that point. My rebuttal is her statements about that second assailant. So I have no problem playing the video that incorporates the discussion about the second assailant. But at that point, I don't think there's any purpose in playing the rest of her interview because I'm not using that to rebut anything.
So, is there anything further from the defense about this issue?
Yes, sir, because innately, I guess, what Mr. Mansfield's trying to argue is that, we're not going to use these cuts, but we're going to go ahead and cut it right then and there. And, again, you're removing all context of where, what was happening, what was going on, her state of mind at the time, You know, I mean, you're really, you know, again, if you're going to use this as a rebuttal, you have to provide the complete picture.
There is a rule of completeness, but that doesn't go to the entirety of the interview.
No,
If there was some statement that she made and they chopped it off in the middle of the sentence or within a paragraph that explained, that would be one thing, but there's no obligation to play the entirety of the interview.
Well, it's not that long, Your Honor, and to be quite frank, I mean, I'm looking through the deposition here, and that's exactly what they did. They chopped out different sentences.
Well, as long as those sentences are not misleading or they're, but...
That's why we haven't gotten to that part yet, Your Honor, but I'm saying is, the video's not that long. You know, if it's the first one, if that's what he wants to use, I don't see why we don't just play it in its entirety.
I've already said I'll play that one in its entirety, the first video.
Okay, and that's the only one, that's the only one with the cuts, right?
First, so we both know what we're
in
talking
agreement.
about. The first video.
Yeah, we're in agreement.
Oh, okay, so, all right, fine.
And that's the one we've already watched. So we will be seeing that entire video in its entirety.
The deposition, and I'm almost inclined to want to go through the whole, literally just submit the entire deposition. Because, I mean, again, these sentences are cut out. They're cut out from, again, they're taken way out of context. And if we want to provide the jury a clear picture of what she said, I think we give her the entire, give them the entire deposition.
But that's not the goal.
I mean, he's almost doing it already, Your Honor. He just takes out the stuff he doesn't like.
Well, again, if it's misleading, if it's not complete, but
That
the
would be the
state
case.
is not under an obligation, or vice versa, either party is not under an obligation to present adverse material to their case, especially if it's just redundant as to what the other side already presented. So if there's some particular excerpt that's objectionable, I'll be happy to look at the
Your Honor, like I said, I haven't had a chance to go through the entire thing, right? But as I've seen so far, right, literally, we would have to go through, and again, we're going to have to go through piece by piece by piece. And yes, there's different parts where, yes, it is definitely misleading.
Well,
You know,
okay,
so-
well, let's get started because I'm
Oh, and the other thing, Your Honor, I did have one more issue, or not issue, but one thing I'd like to address is, okay, if they want to go ahead and play this video as a rebuttal, we have videos that actually add context to this video that we would like to play.
okay, so,
The defense doesn't put on a rebuttal to the state. I'm rebutting evidence he introduced yesterday with that video at the hospital and the deposition. We've already covered the video from the hospital. I would submit we need to start going through the different deposition statements and see if the court will make a ruling as to whether we should be able to go into those or not.
In all honesty, Your Honor, I mean, we should have been, this should have been addressed before we came in today. I would say, you know, I mean, it's not like I haven't been, you know, available for communication. I haven't been available to go ahead and, to go ahead and look at these things. But what I'm saying is, okay, again, she says things in this deposition specifically in response to things that, you know, happened outside of the deposition. And again, it takes it out of context.
okay, well, again, let's look at the specifics because that's
Okay.
how we handle it.
I would agree. That's fine, Your Honor.
Okay, so this deposition was a discovery deposition?
Yes, sir. Back on May 1st of 2019.
Do you happen to have a copy I could look at? or-
Judge, I gave you the excerpts.
You gave me the excerpts, yeah?
You want the entire deposition?
I can actually email
I have
to
it.
you.
Well, thank you. Okay, so,
Judge, first and foremost, let me draw your attention to the beginning. The witness was sworn in, so we covered that. The first excerpt the state intends to potentially use is on page 13. It's a rather involved question and answer about identity. Yeah, and dark clothing, I don't remember, it's been a
oh,
year.
wait.
Hold on, could you please just give me a second to pull it up so that I can follow, please.
Right. Page 13, line 1, just reading from the, actually, from what I can see, it's lines, you want to use lines 1 through 25.
Yes, sir.
Okay, so go ahead, read it.
The first one. Is
Actually, I can read it. I don't need you to.
Fair enough.
read out loud. Let me read it. Is there an objection to this excerpt?
Well, just 1 second. I just got it up there. So, let me see what it says here. This is what I'm, okay. I don't have anything necessarily in opposition to in this section, Your Honor, but she does go into, later she actually says some things that add to this section.
Okay. Frank, if you have no objection, that's fine. I honestly, starting at the top of the page, it's like confusing. I don't know who it's talking about, and moreover, it doesn't seem to be inconsistent. She's talking about Rory Wilson, at least on. So what?
Judge, may I jump in?
Yeah, go ahead.
So, I included the beginning of the page just for context, but she really gets down to it. Line 10. Are you sure it was Rory Wilson? Absolutely, without a doubt. Who else did you see there that night? No one that I can identify. Do you know Ty Tucker? I know him, yes. Did you not see Ty? Not that I can identify. I saw another person, but I can't identify him. In the perpetuated testimony yesterday, she was adamant 100% when Colorado asked her that it wasn't Ty Tucker. Here she's saying she can't identify the second person.
I understand that would be inconsistent with the testimony. I just didn't, again, understand how the portion about Rory Wilson. But again, if it's given context,
Your Honor, could I again interject here? I don't mean to. I don't want to step on your toes, but okay. But this is what I meant by the videos again, because okay, it is inconsistent with a statement she made, but she also says in her videotape deposition that mentioned was the perpetuated testimony. She says there was a time there the detective Pitcher had her thinking it wasn't me, and unfortunately, this is the result of that time, which we have the videos of where he is confusing her. He is giving her other information. He's feeding her information saying it wasn't me. That is, again, not inconsistent with what she says in her perpetuated testimony. She says exactly that.
well, I'm going to overrule the objection. I mean, if
I just think it would prejudice the jury to think that, man, she's actually saying something. Again, she is in different states of mind depending on when these were asked.
right, this happened immediately after the
No,
episode.
not the deposition.
Oh, not the deposition. You're right. But in any event, I think that that's.
I think in all fairness, we should show the context. I mean, again, she says that Detective Pitcher had her questioning at a given point. And I can see why when you look at the videos.
Okay. In any event, I'm going to allow this particular excerpt.
Okay.
So Then we go to the next page.
Page 14.
This is just a continuation.
It is a continuation, Judge.
Okay. Let's see. Let's see. Let's see.
Okay. Is there any objection to this segment?
Yes, Your Honor, because again, this one actually does have sentences that are removed. They have, again, there's things in here that are removed. I'd have to again go over
Sentence.
quickly here just to make sure that,
Sentences that were removed.
yes, there's statements that are actually removed from this. I mean, if our copies are correct, it's.
Page
mine seems to be-
14,
Yep.
lines 1 through 25. What's removed?
Okay, let's see, we've got, and you saw two people.
This is the, I'm looking at the transcript. Just,
I'm just making sure mine is on par. And initially said, yeah, see, okay, no, she was the second person accountability club, Troy, I think we're staff, Matthew Bonnett. So far, nothing consistent. Did say that. See, and this is where I'm getting it at here, right here. This is the section where it's been removed, Your Honor.
what
Says,
section, sir?
No, I can't. I don't remember. I know at one point a small knife fell. I know at one point another stick fell. I believe that is when Roger got it, but you were talking a year and a half ago, and they are memories that I try to hide, so I can't answer that honestly.
Why do you say that's been removed?
Because I don't see all of that there.
Well,
I mean,
I don't know.
maybe the
What I've been given, it says the whole page.
Because, I mean, I'm looking at it, Your Honor, it goes, okay, let me see.
Goes page 14.
Oh, you know what, hold on, I may be mistaken, hold on a second. Flip the page here. Okay. Now, let's see, we're at line 20, just a second person. Okay, and you were, checking again right here. Now, can you see the same numbers? Okay, I'll backtrack on that, Your Honor. It was my mistake. I was reading the wrong section.
So to be clear, Judge, nothing has been removed.
But let me again check it for inconsistencies, though. I want to see where we're inconsistent here. Because, okay, the only thing that I see that's inconsistent with this is, that she thinks that, at one point where Rory Wilson has the Billy Club, which again, I don't see how if he's on top of her slicing her throat, she thinks he has a Billy Club.
Well, Judge, it doesn't matter what he thinks. She said in her perpetuated testimony that the guy on top of her had a knife to her throat, and the other guy had the Billy Club. And here, she's putting the Billy Club in Rory Wilson's hand.
Again, this goes back to state of mind.
Yes, and those are all subjects that you can make closing argument about. The issue would be weight and credibility as opposed to admissibility. In other words, I admit it, but if you care to and you believe that this was she was confused, that her mind had been somehow or other impacted by some other event, or that it's unworthy of belief, that goes to the weight and credibility. It doesn't go to the admissibility.
No, and Your Honor, I would agree, and I'm just saying that she did make those statements in her current state. In her current statements, she said that she was confused by Detective Pitcher.
Okay.
Now, the only other thing, Your Honor, actually, hold on, let's make sure I'm correct here. No, you go ahead. as far as that section, I have nothing else, Your Honor. We're good there.
Page 15, lines 1 through 25.
Judge, before we do that, so on page 14, is this court ruling that the state's allowed to introduce?
Yes.
And what bothers me about what the state's doing here is the fact this is the victim here that they're trying to discredit. I mean, they're treating their victim like she's a co-conspirator. I mean, it's crazy. If the victim says what she says, it's what she says, and they're unbelievable.
Any objection to this page?
Your Honor, quite honest, I'm trying to remember exactly what Ms. Belmont said in her testimony as far as the altercation. I'm not sure if it's, I can't honestly be sure if it is or it isn't.
Well, let's hear what the state's explanation is or argument.
Very well. Page 15, she clarifies who was in what position. During her perpetuated testimony, she was all over the place about who was where and who was doing what. So here she somewhat clarifies that when Matt came up the stairs, Rory was behind him, and who was facing Rory when he came up the stairs, et cetera, et cetera. So she clarifies a lot of where she was on the perpetuated testimony, which was all over the place on who was where on the inside. She also clarifies about there being a small knife that fell. She wanted to get it.
Your Honor.
Yes, sir.
The small knife is in reference to a knife that Roger Ruggett had, and yes, you did try and go after it. I don't see where that, again, I don't know where that's going to come in as inconsistent. But as far as, being all over the place, again, she seems to be all over the place in here, too, as I'm reading it.
Yeah.
Maybe I'm reading it wrong.
Well, I would agree with you there. Is there an objection or not?
The only objection you would get from me, Your Honor, is I don't think it's inconsistent. I mean, she's all over the place. I can barely keep up with. I'm trying to picture in my head what happened here, and again, it is all over the place.
Well, yeah, I mean, Mr. Mansfield, unless there's something specific, it's really just hard for me to be able to pigeonhole this into a prior inconsistent statement. It just seems too broad to me. So I would be inclined to sustain the objection.
Okay. Judge, and that was it. It was just basically lines 12 through 18 about who was where coming up the stairs and where was he in relation to Matthew Bonnett. But it is vague, and that's fine. I understand. I won't use 15.
All right. So now we're on to 16, lines 13 through 25. Mr. Tucker?
I'm looking at it again, Your Honor, because this would be one of those where I was talking about lines being cut out, because it is starting off at 13.
Yeah.
And I just want to make sure that there's nothing that adds to context, before that or after.
Well, there's nothing special about the pages. It's not like they're organized by,
That's all.
they're not organized by subject matter. They're just, chronological recordation or transcript of what was said.
Line 13. If that's not inconsistent as far as the littler person, dark clothing, that's not inconsistent. Okay, this is what, okay. Yeah, so you heard the second person speak. Yes, I think we killed him. That's what I heard him say. What I would ask the prosecution, what's inconsistent here?
Judge, what's inconsistent is, right at the beginning, I couldn't see the second person hardly at all, except he was the littler person, and in her perpetuated testimony, she's giving these statements about being 100% sure it's not Tyrone, it wasn't his physicality, it wasn't his stature, it wasn't his walk, it wasn't his persona, whatever. She went on a whole litany of explanations, but the truth of the matter is, here in this depo, she says, I couldn't see the second person hardly at all. In her perpetuated testimony, she was adamant it wasn't his walk, it wasn't his this. It's completely contradicting what she testified to.
Your Honor, if I
Yes.
may.
Mm-hmm.
Again, I don't see it that way because, okay, she does say that she has trouble seeing him because, Rory Wilson's on top of her and she only sees parts of it, parts of it. She actually later on goes to say in this one that their best view is when he actually goes down the stairs. Now, at that point, she definitely can see size, and she does say that he's smaller than Rory Wilson. She repeated that many times in the perpetuated testimony. Again, again, I don't see where it's inconsistent here. I mean, it may be a little bit, again, maybe, I don't know, confusing, but it's not inconsistent.
Well, did she ever say definitively who among those two people said, I think we killed him?
She thinks the second person said that, but she said here that she barely saw the second person, and she heard the second person say that. In her perpetuated testimony, she was adamant the second person was not Ty Tucker.
Well, she doesn't say specifically in this that it was or it wasn't. It's not inconsistent. She just doesn't say it. She doesn't mention it.
Well, I think that the statement, I couldn't see the second person hardly at all, except he was a littler person. I think there's an inconsistency there in terms of one's ability to be so adamant as to who it's not. Now, if you want the rest of this stuff carved out, I might be inclined to do that, although I think this is precisely what you were concerned about, Mr. Tucker, as to context.
I would agree. I'm looking at it right now. I'm just trying to figure out context right here. It's like, okay, because I know she makes other statements, and I haven't, Your Honor, I did not have enough time to go through the deposition in its entirety. I'm happy we're doing it now, but so I haven't had a chance to look at the entire thing. But I do know she goes into it later, where she's talking about, again, she sees different details. Just because she only, they pick out one detail here doesn't mean she doesn't, say other details in another section.
Well, in any event, I don't understand why this business about Todd O'Quinn at the end is in there.
I can take that out.
I mean,
again, it was for context, but leave it in or take it.
Well, so line 13. Okay. Okay. Line 14, line 15, line 16.
I think I would actually would object to those, Your Honor, just because she doesn't say who says it. Like, she doesn't say that it was, she doesn't actually get asked whether or not, she recognizes the voice, anything like that.
Judge, I would propose that we potentially cut it off at line 18 because that's the sum and substance of the identification.
All right, so
So we're just going to go from 13 to 17, is that correct?
18.
To 18.
18 answers the question.
Okay, yeah, I mean, that would be
All
fine.
right.
That would be fine, Your Honor.
So now we're on page 17, 14 through 25. What about this one?
Okay, this would go back to that whole picture thing. Because yes, he does confuse her and has her at a point where, and she says that it's not inconsistent with what she said in her perpetuated testimony. She says specifically that Pitcher confused her about things, and she says right here that she is confused.
Where does she say?
Well, I mean, she's not saying specifically she's confused. What she's saying is, no, because I didn't know he had anything to do with it, or if he had anything to do with it, I didn't know what they all lived together. That was being perpetuated to her by Pitcher. And, again, he specifically sat there and told her, Ty Tucker did this, Ty Tucker did that, Ty Tucker, has a long rap sheet, Ty Tucker has all this other stuff, and he's literally pumping her full of it. And
So,
she says that, and she says that it confused her.
Where's the inconsistency here, Stig?
Judge, during the perpetuated testimony, she talked about knowing that it wasn't Ty, that Pitcher had told her, and she kept saying to Pitcher, are you sure, because I don't see it, I don't see it.
That's
and
why
here she says, didn't you tell him at the time that you knew he had nothing to do with this? No, ma'am, you did not know, because I didn't know he had anything to do with it, or if he had anything to do with it. I didn't know that they all lived together.
And, Your Honor,
So wait, just let me ruminate on this a second. So what is this inconsistent with?
During the perpetuated testimony, she articulated that she knew it wasn't Tucker that was the second person. That is not what she's saying here. Here she's saying that I don't know if it was him or not. I don't know if he had anything to do with it or not at that point when they met at McDonald's. In the perpetuated testimony, she was adamant that he wasn't the second person.
Your Honor,
No, the defense argument is...
Yeah, the prosecution just made it for me. He literally just spit back what Pitcher was telling her. And again, he's sitting there telling her. She's like, "Are you sure? Are you sure it wasn't Ty?" And he's feeding her a bunch of stuff that says it. Says her memory is wrong. And later on, after she found out that Pitcher was lying, yes, it solidified her memory.
Judge, he can argue all day to the jury about what Pitcher put in her head, but this is an inconsistent statement from what she made in her perpetuated testimony.
That's why I say it's unfair to put it out of context when she says that happened, and yes, we know it happened. You just repeated it, but you want to use the section where she was being confused by him.
Was he? I'm sorry. I mean, obviously he wasn't the deponent here.
No. He literally pulled her in the squad car. I don't know how many times, and literally sat there and said, "It's Ty Tucker. It's Ty Tucker. It's Ty Tucker," over and over and over again.
Well, I mean,
and then blatantly lied to her about a whole bunch of things, and she kept on going. Are you sure? I don't think it's Ty. I don't think it's Ty. And she's saying, "Are you sure?" And she is obviously confused by the guy, and she says that in her perpetuated testimony. She, again, there's nothing inconsistent. She says at one time she was confused.
Okay. Okay, so maybe this was one of those times, but nevertheless, it's an inconsistent statement, so I'm going to overrule the objection. So now, page 18, lines 1 through 25.
Yes.
This, Your Honor, I mean, just a quick objection here. I mean, this is one of the ones where I say taking the sentences out of it definitely changes the context.
What sentences are taken
Well,
out of
okay.
it? I see 1 through 25 as what the state's.
Yeah, I'm looking at it, I'm like, okay, let's see, hold on. No, went after, okay, police didn't tell you that. She goes, who told you that Ty had something to do with it, right? Let's go back here. Nobody told me. Police didn't tell me. No. Well, afterwards, when they arrested him, yes. You know, so, and that, you know.
It's not removed.
I'm
It's
sorry.
right there in full.
I would assume you would.
Sorry.
You would want that based upon what you've.
Okay, not afterwards arrested. Yes, okay. I was having lunch with you. Nowhere near him, that's true. And again, I'm looking for inconsistencies here, because there's nothing inconsistent so far. All right. Nowhere near him. Are you sure that he's involved? What kind of question is that? I do think this is confusing. Let's see. I told you it's because the police arrested me. I'm having a little trouble here. I'm just a little confused. This is actually hearsay too, by Your Honor, as far as, man, the things that I say, right? Because, okay, I'd be happy to clarify what I said in there, but, you know, you're taking my testimony and putting it in there.
Well, a statement contrary to interest is admissible against a party if it's in fact contrary to one's interest. You're right, it's hearsay, but it's one of the many exceptions to the hearsay rule, which is why in many cases, statements made by the defendants are admissible if it's against interest. So,
Your Honor, I mean, the thing is, there's nothing against interest in this. I mean, I did make that statement. I made it on video in my interrogation. I mean, that's where I learned about the knife. That came from Captain Phelps. I learned it from there. So it's hearsay from her to me, to Paula, which the state knows.
well, state want to respond
Sure.
to
On the inconsistency here starts with line 9. What kind of question is that? I had told you I can't identify him. The person was wearing a mask. In the perpetuated testimony, she's saying it's not Ty Tucker. Here she's saying I can't identify him. The person was wearing a mask. So here she can't say that. And in the perpetuated testimony, she's saying it was, I don't know who it was, but it wasn't Ty Tucker. That part I know. That's not what she was saying here. So that's an inconsistency.
I would
And
have.
then, if it continues on, it's the context of this conversation. When you get to the next part, in page 19, the night that the police found had Matt's blood on it. That's what he said. That's what Tucker told her. And you hugged him at McDonald's? Yes, I was upset, crying because of what Roy did, not knowing, like I said, not knowing that Ty Tucker had anything to do with it, because I can't identify him as being there one way or the other. So here she's saying she can't say he was there or he wasn't there, and in her perpetuated testimony, she's 100% sure he wasn't there. So that is the inconsistency that is being articulated in the from page 18, line 9, to page 19, line 7.
Again, Your Honor, like I said, I'd almost have to, because again, you're talking about the same thing she said, and I've already argued this a few times, and yes, I understand it's an inconsistent statement, but she says she did this in the perpetuated testimony. You know, she says she did that.
She said she did what? I'm
Well,
sorry.
as far as, her story was, she was confused because of Detective Pitcher. And that's why I suggested if we were going to do it, we might as well play it for context because, again, it's highly prejudicial. And yes, I think it outweighs the value that he has here.
Right. I'm going to overrule the objection here. So from page 18, line 1 through page 19, line 7.
Oh, and I'm sorry, Your Honor. As far as the hearsay, if I remember correctly, I am allowed to add context as far as my words in that.
What do you mean?
If I remember the hearsay exception, I may not be remembering it correctly.
How do you mean add context?
I actually have a chance to respond to what I supposedly said. I can't remember the hearsay.
Well,
exception.
okay. Are you going to be testifying? I guess you told me earlier you were.
Well, I wasn't planning on it, but if they're going to go ahead and put my words in here, I might have to.
Judge, I think what he's saying is that somehow he would be able to get up and flesh this out, and that is not how this works. This is her statement in her deposition that contradicts what she said during the perpetuated testimony.
Yeah, well, okay.
Go ahead, Your Honor. I'm sorry.
Hold it. So let's go back here. I want to be sure before we get into the rebuttal case that you were not going to testify in your own case, because I didn't go through that colloquy, and so based upon what you'd said earlier in the proceedings that you absolutely weren't going to testify, I assumed that wasn't the case. But if that is the case, then I would certainly allow you to testify before the state's rebuttal case if you want to include your testimony in your case in chief. So I didn't go through that colloquy, and I'll be happy to let you testify in your case and tell the jurors that that's part of your case if that's what you want to do.
Okay. Your Honor, I would at this point, I would almost say I'd have to, because the state's putting out things that I said in response to things that happened, and I'd almost have to. So, because that's the only reason I didn't plan on it. I didn't plan on hearsay testimony from me coming in.
I understand. Trials, you can't completely plan, but I want to make it clear, your testimony would be now. This at the beginning of the afternoon. It wouldn't be after, at this point, the state's rebuttal case. So
I would tell you, actually, Your Honor, if I could do it in narrative form as you suggested, yes.
Okay. So, any input from the state? As I said, I didn't go through that colloquy. I was occupied with many other things at that point, but I always, before we go any further, go through a colloquy with the defendant.
Correct.
So
we have to do that if he wants to testify. He's got the right to testify. So.
Okay. So as long as you understand, Mr. Tucker, that's come back and I'd explain to the jurors that there was one more bit of evidence or one more evidentiary presentation, and that would be the defendant's testimony. That's your right. Nobody.
I think at this point that would be the best, Your Honor.
Well, that's your choice. And yes, you within reason, you can testify in narrative form. That would certainly mean you have to speak at a pace, not a rapid pace. And, you know, normally I tell people who do that to kind of break it into segments and just not one run-on, because it's not ideal. It's awkward for a person to ask the questions to themselves. So,
Your Honor, again, if you give me a second so that I can go ahead. I got to figure out where I'm going to start, where I want to end, because I don't want to just run on forever and just rattle off. But yes, I can go ahead and I can testify via narrative form. As far as objections, could I make them from the stand? That's the only question I have.
yes, you'd have to be able to, but of course, the direct is, the cross is subject to the scope of direct within reason, but that can be broader than one might imagine, depending.
Judge, I've never seen it in the narrative. Is there any way to have a lawyer direct him while he's on the stand and have his testimony elicited from a direct examination?
Not a lawyer that I know. I'm not going to. No.
He's got these advisors. I don't know if they're available.
They're not counsel of record. They're
And they're not available, Your Honor, or else I would ask them.
well, then they have to make an appearance, and if they're willing to, put their name back on the dotted line, so be it. But otherwise, that's the way I've seen it done, and it's manageable as long as the person isn't speaking a mile a minute, which I don't think Mr. Tucker does that, and as long as they, pause and,
The only thing I would ask, Your Honor, because I'm just looking for some direction here, because, again, things that happened over the course of this thing, I talked to other people, I had experiences with, different people. I'm sure some of that would be hearsay, it'd be objectionable. I don't know how I curb that, so to speak, and tell the story.
I really can't tell you other than it's
Just trying
like
to avoid hearsay.
any witness. I don't know what to tell you, other than I'm going to assume that the state will make objections they deem to be appropriate, and I'll make my best ruling. So if you want to testify, again, I just want to make it clear that it would be when we get back. It's not in the wake at this point of the state's rebuttal. It's part of your case in chief.
Okay, that sounds fine, Your Honor. It's just, I think it's better. It's best at this time. I wasn't aware that the state was going to do this. That's
I understand that, and again, I'm in an abundance of caution. I'm revisiting the issue about your testimony, and because I'd made an assumption you weren't, but now you are, and that's fine, and that's your right. And so, in any event, to some extent, we're going to continue with this exercise here.
I guess we should, Judge, because I'm still planning on a rebuttal case. So
All right. So,
I think Your Honor ruled through page 19 would be admissible.
yeah.
Oh, hold on. Where were we at?
We just dealt with line 18, page 18, lines 1 through 7 on page 19.
Okay.
Oh, I'm sorry. 18, 1 through 25, 19, 1 through 7. So now, page 32, lines 21 through 24. Did you see who took your purse? The other person with the backpack. And what did the backpack look like? It was black.
That's
Black?
not inconsistent.
It was black. Okay, what's that?
Judge, it was context. I'm not worried about it. We can take that out.
Okay, take that out. Page 33, line 2, 3, and 4. And what was in it? Stuff, perfume, $27. I don't know what else was in it. It's been a year and a half.
I think Mr. Mansfield and I agreed, he wasn't sure if it was inconsistent.
I don't think so.
I wasn't either, so.
I don't think so. She pretty much parallels her testimony that I recollect. So that's out. Page 38. Line 2.
Just give me a second here. Mine's coming from the cloud and it's being slow. Actually, that page only had page. Mr. Mansfield, do you happen to have an extra copy
Of what?
of the original deposition? 'Cause
No.
Mine, it's coming from the cloud and it's just,
I
must
don't have
have
an
slow
extra
internet.
You can look at this if he wants to.
Thank you. Thank you, Your Honor.
Okay, we've got to wrap this part of it up.
Thanks.
There was a scuffle between them, and Roger got thrown like into a tarp. I don't believe I said he was beating him. I was the one getting beat, but there was a scuffle between those two, the other person and Roger. And you saw the second person holding a knife to Roger's throat? No, ma'am. You did not see that? No, ma'am. You were told that? I was told that by Roger. That is why Roger wasn't helping me. And Roger was the one who told you that the other man had a knife to his throat? Yes, ma'am. But you never saw that? No, ma'am. I couldn't see past Rory Wilson because he was on top of me, beating me for the third time. I have told you.
Okay, I'm sorry, Your Honor.
Yeah, go ahead.
I don't see anything
Yeah,
inconsistent here.
I'm trying to see it myself. What is the point here?
The inconsistency, Judge, is that she said she saw the other person, holding a knife to Roger's throat. Here she's saying she didn't see it, that she was told that by Roger, and she says, I couldn't see it because I couldn't see past Rory Wilson, who was on top of me, beating me for the third time. In her perpetuated testimony, she said she saw the second person with a knife, holding a knife to Roger's throat. That's not what she's saying here.
Your Honor, if I may.
Yep.
If I remember correctly, she said she thought the other guy had a billy club, not a knife.
At one point, she said that, but
And then she also puts the billy club in Rory Wilson's hand at one point.
No, that is true. And when I was looking at this testimony, she does. And it's like I told you, she's highly confused right here. And especially the hospital one, she definitely is.
right.
Which is why, if he wants to play the video.
I'll overrule the objection. I believe it's within the scope of impeachment. So page 43, lines 1 through 10. I don't know if he was the driver. Is that the one that was arrested for being the driver? Question, yes. No, I don't know him. Have you ever seen a picture of him? After he was arrested, okay. Who showed you a picture of him? The newspaper. And you didn't recognize him? No. So what's the problem? Is he talking about Johnson?
Yes, she's talking about Travis Johnson here, Judge.
Okay, and so maybe that's inconsistent with the Zoom, but I told him to disregard that. It's not in play, so unless there's some...
I thought in the perpetuated testimony, she said that she looked in the newspaper and saw the picture. You know what, Judge, that's fine. Take this one up. It's fine.
Page 54, 14 through 25. The second person that you can't identify, do you know whether or not that person was white or black? I couldn't tell you. Okay. Only that the person was smaller than Rory Wilson. Yes. And you believe it was a male? It was a male. When you heard his voice, yes, but the voice did not sound familiar to you? No, but it wasn't Rory Wilson's voice. So,
The inconsistency there, Judge, is in her perpetuated testimony, she testified that it wasn't Travis Tucker's voice, and that, I'm sorry, Tyrone Tucker's voice, and that she knows his voice, and she was even specifically asked, do you know if he was masking his voice or not? And she said it didn't sound like it, and it wasn't Tyrone Tucker's voice. Here she's saying, you heard his voice, yes, but the voice did not sound familiar to you? No, but it wasn't Rory Wilson's voice.
all right. So we'll allow it. Page 57, lines 18 through 25. I may have asked you this. The second person that you can't identify that was there, do you remember what that person was wearing? Dark clothing and a mask. Did Rory Wilson have on a mask? Yes. Were the masks the same? I don't know. I didn't get to see the second person.
Again, Judge, it just goes to her statement that she couldn't see the second person, which is contrary to her adamant testimony in perpetuation, her perpetuated testimony where she was adamant that it wasn't Tyrone Tucker.
Anything
This is the last
further?
page, correct?
Page 57, lines 18 through 25 is what.
Thank you, sir. It's 18 through 25. Clothing and mask, she says that. Mask, yes. Mask the same. I don't know. I didn't get to see the second person. And if I remember correctly, in a second. I think Mr. Mansfield and I talked about this. In her perpetuated testimony, she says like it was a hoodie mask kind of thing. Again, I'm not seeing.
I'm sorry, I didn't hear that last part.
I'm looking at the end at the.
Didn't get to
Hold on,
see.
let's see, because this goes over into page 58. It's like,
Well, right, but you said he was wearing a mask, yeah.
Yeah,
Did you
he-
see the person from the back when he was leaving? His darkness, what kind of mask was it? I don't know, it was dark. The mask was dark, like a hoodie mask, the
that's
back.
not, it's not inconsistent.
I can't tell you anything about it other than that, so.
That's what I mean. That's not inconsistent. She said, literally, she said it was a dark hoodie type of thing. She doesn't say anything specific about a mask. She doesn't say anything like that.
Yeah. State,
Judge, 58 was more in context with the last lines in 57 where she says, I didn't get to see the second person, which again completely contradicts what she's testifying to in her perpetuated testimony that she can't ID that person, but she knows it wasn't Tyrone Tucker. Well, how can you say that if you didn't get to see the second person?
Again, Your Honor, in perpetuated testimony, she says specifically she got a look at him from the side. The best look she got at him was going down the stairs. She didn't, because again, Rory's all on top of her. She's getting glimpses of him. She never says that she sees anything. Anything that is, again, is going to specifically.
the point that the state.
She doesn't say anything about the mask, basically.
But-
She says other than it was a black hoodie type thing.
But the point that the state is trying to make here, which they've been trying to make many of these
It's kind of repetitive.
quotes, is that Miss Belmont was adamant it wasn't Mr. Tucker. She was adamant. And then the state's trying to say, how can you be adamant if you didn't see the person? That's the point they're trying to make.
I understand the point they're trying to make, but again, she says that in her perpetuated testimony. The biggest things that, for her that were the identifying features were height, which she did get. She says again, in this she's saying, okay, she didn't get a good look at him, and she does say that in there.
Okay.
But height, weight, and most importantly, the voice.
Right. Well, I believe it's within the scope of impeachment. The only question is, do you want page 58 or not? Because I would think, based upon the arguments you've made, that would almost be advantageous for you. But Mr. Mansfield's suggesting he would strike that, agree to have it stricken. But
No, I mean, if we're going to put the one in the 57, you might as well put in 58.
okay, so that's that. So we're going to come back at 1 o'clock then. And, again, Mr. Tucker, you're you're gonna testify, you've informed me.
Yep.
That's fine. The only thing, and I will make, you can certainly, as we discussed, when it's cross, you can raise an objection. The only thing I think it's important to be mindful of, and I'm not suggesting you would do that, but testimony is different than argument.
I understand that.
Oh, okay. And similarly, when you get to final argument, that's different than testimony. But you understand that distinction, so then I don't need to explain it.
Your Honor, the only thing I do still have a question of is like some of these, like the one where he's talking about, you know, I talk about the knife and all that. I mean, I don't want to get into too much hearsay, but I mean, I was actually told that, so how do I address those type of things when I was told something like that? And that's what I'm telling DePaul.
I really can't.
It's a hairy.
I can't really answer that question.
Just deal with it when we get there.
I'll have to hear your testimony. I'll have to hear if there's an objection. I'll have to make my best decision. But as a general proposition, hearsay is a complicated matter. Judges and attorneys review it and have courses on it and read treatises on it on a regular basis. So your question is certainly not unusual or not something that isn't fairly debatable, but I can only make this rulings when I hear it and when it's objected to.
Tell your story when you can't say who you talked to or what you said.
I'm not here to impose limits other than the rules of evidence and procedure.
Okay.
Judge, I would just ask the court, I mean, that Mr. Tucker should not be able to go into the IA investigations and all the
I have no intention.
collateral things that came out, because that's hearsay. It's not been admitted into this case, and he shouldn't be allowed to testify to it when he's on the stand.
Well, he just indicated he didn't intend to, and I, as a general proposition, would be consistent with what I've ruled thus far. It would be inadmissible, but we'll be back at 1 o'clock.
Okay, thank you, Your Honor.
All right, guys. So as you heard there, a little bit of a unexpected development that Mr. Tucker is going to be testifying. So that should be really exciting. And we were watching this because we thought this was what was going to be the afternoon session. But I figure we're finished watching part 3 because this is the part that Mr. Mansfeld didn't want in its entirety to come in. So we'll see what's in what they discuss. And then we're going on break for a little while and come back with the afternoon session, which should be quite interesting, I think, as Mr. Tucker testifies and gets cross-examined. And then I guess we're going to see these videos played. Of course, the state now can go further with their rebuttal because they're going to be able to rebut whatever he brings up. This whole thing just got very interesting, and potentially we're not going to be closing tomorrow. It may extend this another day or two, depending on what the state wants to do or wants to bring in to rebut whatever Mr. Tucker testifies to. So let's, without further ado, let's start watching this and see what we've got here.
Paula? You got the door?
Oh, my neck hurts.
Yeah. It's gonna hurt.
Oh. Gotta go this way. I won't be long up there, will I?
No, you
I
shouldn't
mean,
be.
want to just go lay down.
Huh?
Really want to just go lay down. Curl up in a ball, get warm. And please sleep with it.
Patrol 1. Just give me 1 second, okay? Sierra 472. I'll have 1 white female on board en route to headquarters.
Copy 23.
Show me around to a follow-up at 337 3rd Road. We reference case number 7951.
I knew when nobody would answer me that that was dead. And that's why nobody would answer me. I knew that.
Oh, you mean the nurses and
Yeah,
stuff?
I don't understand why they just don't. Why won't they just tell a person though?
Huh?
Why don't they just tell you? Why do they just try and pussyfoot you around? Sooner or later you're gonna find out. Why don't they just admit it? I don't understand.
1, because you're not family. They try to tell the person's family first before anybody else knows, so they don't get the telephone calls to the family before somebody could tell them in person. 2, the reason why they didn't tell you is because they didn't want you all upset when they knew you were going to be talking to the police.
Well, of course I'm gonna be upset. The guy,
No, but
he's a friend of mine.
I know exactly. He's a friend of yours, and you're extremely upset, which can sometimes cloud the information that you're able to give us. You understand what I'm saying?
Okay, yeah, but I knew when they're not answering me. I knew.
Yeah.
So they're just saying he's okay, we're working on him. I knew, but they're not saying it. My father's been a volunteer fireman for 63 years. But can you tell me what he said? Todd said he thinks he was. Or you don't know?
I'm going to assume yes, but I truly don't know.
God, why? I know what it felt like just having this in my neck. I wasn't stabbed. I was, he did it. He was pushing on it, and I know what that felt like. I can't imagine what that felt like.
DJ, only 1 going at this time.
I just can't imagine.
Service Delta. I'll be around for that anyway.
Copy 23.
We found the hammer. Me and Roger were looking around trying to find we found that hammer. I wish I'd had it then. So when they'll find a hammer on my floor, it's mine. It's nothing that was brought.
Okay.
It's under the bed. Definitely under the bed.
How long have you been down here?
Business trespass at Bryce Bucky.
14 years.
Okay, so you've been down here for a while.
Yeah.
50 for holidays.
15, the male has been previously trespassed, is going to be inside near the dartboard.
Copy.
So just ignore April again. If she calls me again, just ignore her.
Yes.
41 on
I like I said, I usually have it unblocked. I don't know why it's unblocked. I don't talk to her anyway. She's not trouble. She's no good. Oh, what about cots?
Oh yeah, they might. If they're open, yeah, we can go.
You know, I mean, no, I don't have no shoes. Nothing. No, I don't want to see that.
Okay.
I'll go to my second meet on the door. He'll wake up.
Subjects that are being trespassed.
I'll be more comfortable then. You know, cause I have to go in and just go to sleep. I don't think as much as I want to lay down, I don't normally go to sleep right away.
You know, you're probably not going to be able to go to sleep right away. I'm going to be completely honest with you.
You're not leaving, right? You're not leaving.
No, we're going upstairs.
11:20. Copy now. Walking up Catherine Street, Victoria. Give me 3236 Catherine Street, 3236 Catherine. Negative answer in text. 11:40. Copy.
So I want to make a note there. I don't know if you guys have heard this. I heard this several times, but it appears Detective Malone's ringtone was Law and Order. So that's an interesting choice for a ringtone, I think, for a police officer. Anyways, see here. We have a comment here. I don't think he needs to testify. State has one witness that was offered a plea deal, and Tucker has a witness that says it wasn't there reasonable doubt. I agree with you, Nick. I don't think, and that was where he was going. He wasn't going to testify, and then Mansfield baited him into testifying by putting up this information because he's concerned that there's a statement in there that he wants to be able to rebut, and the only way he's going to be able to do that is testify. So, I mean, in the end, he's going to get to put his story up. He's going to have to answer questions. I think, you know, since part of his motivation in doing this was to show the world, show the public that he's innocent, not just not guilty. This is going to give him that opportunity. And it's going to give the jury the opportunity to contrast whatever the story he tells them with the story they've heard from others. But I absolutely agree with you. I don't think he needs to testify. I think his case is in a great position right now. I think he's going to get found not guilty, but I think he really, you know, obviously is concerned, and he wants to make sure that he can defend himself the best way possible. So, you know, that's what we're dealing with here. You know, unfortunately, sometimes, you know, that's why having an attorney there to help you navigate things and figure things out is sometimes helpful, because it helps take the emotion out of decisions. Because that's kind of what happened here. He got baited into an emotional decision in court. He's, you know, and now he's going to testify, and we'll see what happens. But I think it's going to be very, very interesting. Now, with that watched, I'm going to show you, we're going to review one last thing, and then we're going to take a break, and we'll be back for the afternoon session. And that last thing here, give me one moment. All right, so I thought it would be interesting to take a look. This is the motion that he filed this morning, the motion to continue, and go over what exactly was he filed. This was referenced in court. So here it is. This is the motion straight from the Monroe County website. And you can see this is the contents of it. Comes now, pro se defendant Franklin Tyrone Tucker files this motion for continuance to allow adequate time for the defense to prepare and properly serve a motion for disqualification of the presiding judge in this case, the Honorable Mark H. Jones, on the grounds that the defendant does not believe they can receive a fair and impartial trial, and that the deadline for filing such a motion is 20 days. The date of discovery for this motion will be recorded as January 22nd. Defense also proffered that because the motion for disqualification is being prepared during the course of the trial in the instant case, that no further action can be taken for the immediate cause without first resolving the issue, giving rise to a motion for disqualification. That to continue the trial under these circumstances will only cause the defendant to suffer the exact miscarriage of justice that the motion for disqualification is seeking to avoid, resulting in denying Mr. Tucker his constitutional right to a fair and impartial trial by a jury of his peers. Therefore, the defense would move this court to grant this motion for a continuance of 10 days, which is exactly half of what is provided for in Florida Rule 2.330. So there it is. That's what he's asking for. Obviously, one of the things that's going to be a little problematic that hasn't been done yet, that should have been done, was when this judge decided to not allow him to call Seth LeVay, he needed to get a proffer on record of exactly what he intended to have Seth LeVay testify to. And you could do that in two ways, by either getting the document that which is the motion to suppress, where Mr. Johnson, Mr. Johnson's attorney on his behalf, and again, remember, anything filed in court, when a defendant files it, or when an attorney files it on behalf of the defendant, it's as if the defendant filed it. And the issue of attorney-client privilege would not extend to that document that was publicly filed in the case. And in that document, it's supposed to contain information to the idea that they were alleging that they wanted his statements suppressed, alleging that the statements were false and that they were fed to him by Detective or Captain Phelps. And the problem with that is Mr. Johnson just testified in court that that wasn't true. And now he files a motion saying that it was. The jury should hear this. And the judge took that out. That's what is the genesis of this motion, because once the judge kneecapped Mr. Tucker from putting that information before the jury, after already allowing Johnson to testify as he did and go in there and say what a great captain and what a great investigator Penny Phelps was, knowing that he had filed this motion, to which the judge wasn't going to allow in at that particular moment or question regarding it because proper foundation hadn't been laid for it. But that was part of what he was going to do in the defense's case. And it opened the door to the state. The state opened that door. But again, because the state is taking advantage of Mr. Tucker in this case, it's part of why many would say you should have an attorney to take care of these things for you, so you can make sure this stuff gets entered and taken care of. But the issue is this needs to get proffered on the record so that the appeal court can have the proper record to consider. Not to mention, now the judge didn't definitively limit him, and that's what he was kind of worming out. That's in the record now, where he says, hey, we have the state even realizing that they really did create a problem with this issue with the subpoenas, taking advantage of a guy who doesn't understand how everything's working. State caused us delays last week. I know it was part of the potential. They estimate that Mr. Tucker's going to have a longer cross. They have no witnesses. Things go further in. And the state at that time was saying they were going to finish their case around Thursday, Friday. So Mr. Tucker believed and had these witnesses lined up, and then the subpoenas expire, and then the witnesses don't show up. And it looks really suspect when you look at it. And you'd think that the judge, the prosecutors wouldn't want this type of thing hanging over the case, because it's going to be that very thing that if Mr. Tucker ends up convicted at the end of this thing, those are the things that the appellate court, I think, obviously would look into. And hopefully Mr. Tucker would hire an attorney at that point to review this case if that should happen. Hopefully it does not, because I don't think the evidence supports that at this point. Now, but this is the motion for continuance that we have right here on record as we're speaking. So The judge, of course, denied it, and that I don't think that was unexpected. I don't think anybody expected the judge was going to continue this case with a jury sitting there. He's been very adamant he wants to get this case to a jury, and he certainly isn't going to allow for a 10-day suspend or continuation, and that just wasn't going to happen. So, here we are. But we will be back. It looks like, I believe, court is back in session at 1 o'clock, so we're going to take a 30-minute break, go offline here for a minute, and then we'll come back on live to watch what should be a very, very interesting, very, very fiery, I think, second half of the day. And we'll go from there. All right, guys. We'll talk again shortly. Until then, let justice prevail.